Thanks for staying with us. As promised, Supreme Court upholds death sentence for farmer in self-defense case is the issue we'll be discussing right now. Remember that the Supreme Court has upheld the death sentence of Sunday Jackson, a farmer who killed a Fulani herdsman allegedly in self-defense after being attacked on his farm. Despite suffering injuries, Jackson overpowered his attacker, seized the knife and fatally stabbed him. The court ruled that he should have fled instead, convicting him of murder. The verdict has sparked outrage, with critics calling it a miscarriage of justice. Human rights advocates are urging Governor Amadou Fintiri of Adamawa State to grant clemency, arguing that Jackson was only protecting himself. The governor's office has yet to respond to growing calls for intervention. Now, this case has reignited debates over self-defense laws in Nigeria, especially amid rising farmer-herdsman conflicts. Many believe Jackson's conviction highlights systemic injustices, with his fate now resting on public pressure and the governor's decision. Our guests this morning are Barrister Asia Elvis, legal practitioner, and Ngozi Dorothy Moloku, NDM. That's the acronym. CEO, founder, Injustice is Real. Lady and gentlemen, good morning and welcome to the show.
Good morning.
Good morning. For having us on the program.
All right, let me start with the lady. Ladies first, as they say. So speak to this topic of discussion this morning. We're hearing that Sunday Jackson allegedly defended himself and so in the process murdered or killed the other person. And now he's being sentenced to death. What do you say about the whole case? Are you part of the people advocating that he should be released, and why?
Okay, thank you for that question. Let me just clarify. I'm not a legal practitioner. I'm a human rights advocate.
No. I didn't say you were. I didn't say you were.
That's fine. Thank you.
Yeah.
That's fine. Thank you. Okay. Now, in terms of your question, yes, I veer on the side of human rights advocacy because that is what I champion. And I'm calling for this case to be reviewed if clemency can be granted, to Sunday Jackson, because when you look at the prosecution's case, what they took into account, the confession statement, the caution that was also issued, definitely, and the medical evidence that was presented. Without a doubt, well, firstly, let me just take us back a little bit, because the Supreme Court's ruling was that the prosecution needed to prove beyond a reasonable doubt a few points, beyond a reasonable doubt. And I question the caution that was granted that was given to Samuel Jackson, that the police gave, the caution they gave. How was this caution given? Because this was the evidence the prosecution presented. How was the caution given? How was that caution taken? Was it taken under duress? He was in a police station. Who was there? Who was the witness? Who was the other witness, apart from the police officer? Yes, he confirmed the statement that they read back to him in Hausa language, and he signed, and the police countersigned. But who else was there? Was there another witness apart from just himself and Samuel Jackson? So already that creates reasonable doubts. The caution and another thing is the caution that was even given by the police officer. What was the caution? Was his rights read to him? We need to know what the caution was. If not, it creates doubts as to what the caution that was read out to Samuel Jackson. Now, apart from that as well, I just bear with me because I made some notes. The issue of self-defense as well, we really need to look at this, because the Supreme Court ruled that self-defense, they can take a confessional statement to secure a conviction of self-defense. And obviously, as we all know, Samuel Jackson gave a confession statement here. But looking at that confession statement, as I mentioned, how do you determine that, self-defense? How do you determine that this wasn't a case of self-defense? Because the court had ruled, apart from the confessional statement, the court had also ruled on the issue of self-defense that he should have fled. the scene of the crime. If as he had the opportunity, he should have fled. But if we look at the actual facts of this case, the herdsman actually stabbed him on the back of his head and also stabbed him on his left leg. So what he clearly had an injury. How was he able to flee? Did anybody analyze the scene, the crime scene? Was any evidence taken at the crime scene? What was looked at here? How is he able to flee? Do we know if his leg was badly injured to a point where, at that point in time, he could not flee? It was not possible for him to get out of that situation or even throw the knife away, as the court had stipulated. So, these are the things that create a lot of doubts. And where there's reasonable doubt, it has to be looked into, because the prosecution needs to prove beyond a reasonable doubt. But have you proven beyond a reasonable doubt, though, that yes, he did these things? What was the state of his mind when this incident happened? Was that looked into? Did anybody assess his state of mind when the incident happened? When the herdsman launched at him with a knife and he was fleeing, he was screaming, he was shouting, nobody came to his defense. Did they look at these things? Was there diminished responsibility? Did they look at it at all? Because if there was diminished responsibility, i.e., he lost control of himself, because from the facts of the case, he wrestled the herdsman, took the knife, and stabbed the herdsman back in the neck. Now, at that point, what was his state of mind? Did anybody consider his state of mind? Was his state of mind evaluated to know if he lost self-control? Was there diminished responsibility at play here? We need to look at all these things. How do we just give a ruling and say, yes, he's guilty of murder? At best, manslaughter. We're not doubting that the herdsman didn't die. It's not in doubt. The medical team, the coroner probe, they looked at the body, they said, yes, it was caused by the stabbing in the neck. We all know that. And we're not saying no, that he didn't kill the man. We know he did kill the man. But we have to look at the circumstances, though. We have to take these things into account. If not, it's a gross miscarriage of justice. And that is what I see in this case.
Okay, Barrister Asia, speak to this. What is the place of, what does the law say about self-defense and the place of the issues that Ngozi has just raised now, evaluating the psychological effect, situation during the committing of this act, during when this act was being committed, rather, and so many other things she raised there. Are these things supposed to be valid points when it comes to law?
Quite frankly, I appreciate the point that Ngozi made with respect to some of the issues. But unfortunately, the legal process, it's a matter of evidence. It's a matter of the issues that are submitted before the court. I've had the opportunity to read the judgment at the Court of Appeal level. I haven't seen the judgment of the Supreme Court, but I've looked at the judgment of the Court of Appeal on this issue. And quite frankly, it is difficult, extremely difficult, to fault the court on the basis of our laws as relates to the self-defense, and also on the basis of the facts that were placed before the court. Yes, it's a constitutional right to be able to defend yourself, and if somebody, in doing that, and somebody dies in the process, that death will not be considered to be murder. But however, for you to exercise that constitutional right, there are called legal considerations, factual issues that must be considered. One of which is, first, was there an imminent threat of death, of harm, serious harm to you at the point? And what is the nature of the steps that you took? Is it proportionate? Was it necessary? Was it reasonable? So these are some of the questions that the court will, look at from the facts and circumstances of the case. And if you look at the facts of the case, from the confessional statement that was made by Mr. Jackson, it is clear that he wrestled with this person In fact, he didn't say that he was stabbed. He said he attempted to stab him, and he wrestled with him, and took the knife from him, and he stabbed him 3 times, on his throat. So you don't look at that. It's difficult for you to maintain the defense, self-defense in that circumstances, because like the court, at least at the Court of Appeal level, stated, which I believe has been reinforced by the Supreme Court, is that having taken the dagger from the man, you have taken out the threat of imminent death to yourself, and you have the opportunity to run. You could have stabbed the person in another part of his body in a manner to ensure that you're able to escape and all of that. And contrary to the information out there, from the confessional statement that I have read, which was placed before the court, the man didn't say the Fulani herdsman actually came to maybe graze on his crops or whatever. What happened was that it appeared that the man, the disease, was running after people who he claimed had stolen his cattle, and he perhaps saw this man thinking maybe he was part of them or whatever it is, and the attack, occurred. So, I think we need to be able to separate the place of sentiments and emotions from core issues of law. We're talking about human life here. It doesn't matter whether it's a herdsman, whether it's a Muslim, whether it's a Christian. We're looking at the value of human life, and you cannot allow, the law cannot allow it to be taken, so easily, when there are other options that could have been taken to protect yourself. And I think that is what is at play here. The right to self-defense is not a blank check that you can use to kill people, quite frankly, unless you can demonstrate from the facts and circumstances of the case that it is, expedient, it is necessary, it is reasonable, and the force and the steps you took is proportionate to what is required to protect yourself in the circumstances of the case.
Okay, let me get this straight, Barrister Asia. Let me get this straight. When Ngozi was talking, she talked about the fact that the accused, or the convict now, was stabbed, maybe on his leg and somewhere else on his body. Does it mean that when you saw this judgment, there was nothing that reflected that he also had an injury that could have been fatal that was inflicted on him by the now deceased person?
The Court of Appeal decision I have seen and the confessional statement that was made did not say he was stabbed. He said he attempted to stab him, and he wrestled and he took the dagger from him. He said he wanted to stab me with a dagger. Then we engaged in a wrestling encounter. He wanted. So there's no evidence before the court that Mr. Jackson was injured from the encounter, which may have, justifiably prevented him from, for example, of trying to escape, maybe by running or whatever it is, and then he was not able to use the dagger to, dagger the man by the throat on 3 occasions. So, a lot of the information that I've seen on social media on this issue, they are not born out of the exact factual situation that was placed before the court and the issues that were placed before the court. So it's not a matter of
the confessional statement.
Ngozi made the point about the confessional statement.
Yes. Yeah, okay, maybe that's the same thing you were about to say. Ngozi said something about the confessional statement and raised the question. She raised the question
how the confessional.
Yes, how it was obtained and who witnessed to it. Yes, go ahead.
I was obtained and all of that. That ordinarily would be a valid point, but it was not an issue before the court. The lawyers didn't say the confessional statement was made under duress. At least from the evidence, from the appeal that I saw, the issues that were raised on appeal at the Court of Appeal level, because like I said, I haven't seen the full details of the decision of the Supreme Court. The issues that were before the Court of Appeal had nothing to do with the mode, the way and manner the evidence was taken. There was no issue about a challenge to the circumstances in which the confessional statement was taken. The only issue was the implication of that statement. It wasn't challenged, at least from the case I can see at the Court of Appeal level. So yes, that would have been an issue because we know that in cases like this, there's a possibility that somebody could be coerced somebody could be forced to make a statement, because I've read the statement, and quite frankly, it is too direct. It may suggest that there were some forces at play that may have gotten somebody to make this kind of statement. But however, it wasn't an issue before the court. The court of law is not going to speculate.
Okay, I get you. Let me go to Ngozi. We have very, very short time now, but so Ngozi, stay as short as possible. Now you've heard what the side of the story from the court, as it were. How would you argue your case now, Ngozi? I'm back to you.
As I said before, there are a few things that we have to consider here. Yes, evidence was tendered in court. We saw all of these things. And I don't know what case the barrister has seen, but I saw the facts of the case. And he was injured at the back. The herdsman actually stabbed the farmer at the back of his head and on his left leg. He did. It's there. It's clear in the notes. Now,
I'm wondering why this was not placed before the court, like the barrister is saying. Why was it not placed? Because he did not dispute that fact. But he just said that this was not one of the facts that was placed before the court. So they didn't give the judgment based on that.
I don't know why they would not have done that. If I was arguing this case, I would definitely have presented all of these things. Because the first thing is the caution. What was the caution that was read to the farmer? What was the caution? Who took the statement? That statement that was taken as well. Who was the witness that was there? Who was the second witness? Who witnessed this statement? We can't just take these things at face value. Why do we have the beyond a reasonable doubt test? Why? We have it because it says you must prove your case beyond a reasonable doubt. And these things cause doubt. There was a case in the UK of Tony Martin. Now, very similar case here. Two young boys, they invaded Tony Martin's property to rob him. Tony Martin was upstairs in his house. He realized somebody was in his house. He took his shotgun, ran downstairs. One of the young men fled the property. The other young boy, unfortunately, was struck by the bullet of the Tony Martin's gun. In this case, he was convicted of murder, but they downgraded it to manslaughter because of diminished responsibility. So why can we not look at these things? What was his state of mind? What was the farmer's state of mind when he was launched at with a knife? We have to take these things into account. If not, then we fail the beyond the reasonable doubt test. We fail, and it's a miscarriage of justice. So we can't conduct things like this. This is a man's life. Yes, unfortunately, the herdsman died. But are we now going to take another life? He's done 10 years already. So we should throw this thing out and allow him go. It has to be a case of manslaughter and not murder. We have to look at every circumstance here. If not, then what's the essence of this beyond a reasonable doubt test? Okay. We fail that test. We don't consider every circumstance. We fail.
Barrister Asia, before we go, maybe this is a yes or no answer that you will have to give. Ngozi is harping on the fact that mental stability, everything should have come into play when deciding this case. Do these things in the Nigerian courts even have any role to play? Do they ever get considered? Like you're thinking about the state of mind of the person, you're thinking about the circumstances surrounding the commission of this crime and all that. Do these things ever have a role to play in our judicial system? Because if it does, then it would be like maybe it was.
They do have a role. They do have a role to play, and when established, it can actually affect liability in for a crime. And so she's right in that regard. But the point I'm making is that those were not issued before the court.
Yeah. So at this point now, you have answered this. At this point now, let me ask you. Well, if all these things were there and they were not looked into, they were not placed before the court, will you put the blame for these, where we find ourselves now, will you put the blame on the legal team of this Sunday Jackson? And if you put the blame on the legal team, what legal team was it? Was it the state legal team? Was it a pro bono thing? Or was it a Sunday that could afford the legal representation that did not even look at things as important as this one? Will you place the blame on the legal team of Sunday?
Well, you have to. I mean, I can't be blaming any legal team here, but you have to consider that from some of the information we have seen at the trial court level, the kind of representation that the Mr. Jackson got was, pro bono representation from legal aid or something, and that, I don't know. I haven't seen the trial court judgment to really be able to evaluate and assess whether or not that representation was, of such a quality that is required in a murder trial.
All right.
But I can say that, if I've been defended by legal aid, I mean, the chances, and I can't say that my water.
Yeah.
That may be an issue.
I see how careful you are, but it means that if you represented him, you probably would have done differently from what he did. And that is what stands now. Nobody is to blame now, but you could have done something else and taken a different approach. That's what I can deduce from all your talk. But this is how much we can take. We've really, really run out of time, lady and gentlemen. So we'd like to thank you for your time this morning and hope that the best possible outcome is what we'll get from this case. So Barrister Asia Elvis, thank you for your time, and Ngozi Moloku, thank you also for your time.
Thank you for having me.
All right. Thank you for having me on the program.
Okay, Barrister Asia Elvis is a legal practitioner, while Ngozi Dorothy Moloku is a CEO founder in Justice is Real. We're talking about the person facing death penalty for defending himself. And we heard two sides of the story, but we, like I said, hope that the best outcome is what we'll get from this. And this is where we draw the curtain on the program this morning. It was a pleasure having breakfast with you. We hope that you will join us tomorrow for another edition of the program. In the meantime, on behalf of the entire team, my name is Nyamgul Agaji. Thank you for being there.